Hi, welcome to LA Law Library. My name is Sandy Levin and I'm the Executive Director here at the Law Library. And today we're presenting Workplace Sexual Harassment, Know Your Rights. So we want to welcome you, let you know that we are open 6 days a week and one evening here at the downtown branch, and we have locations throughout the county as well. So if you need help with legal information, please look us up, go on the website at lalawlibrary.org and find our calendar. You'll find classes, workshops, clinics throughout the year, and we hope that you'll join us and get more information to help address your legal needs. In addition, we have one-on-one reference assistance at the reference desk, and you can get help with doing your own legal research, understanding what your legal rights are, or representing yourself within the judicial system. So today I'd like to introduce you to our two presenters. Courtney Abrams and Demry Ryan are here. They are both experts in this area of the law, and they'll be talking to you about sexual harassment. They're both practitioners in employment law with their own practices, so they bring a world of experience and a lot of knowledge about this topic, and I know you're going to learn a lot today. Thank you.
Hello, it is wonderful to be here. Thank you for joining us. And as Sandy said, I'm Demry Ryan.
And I'm Courtney Abrams.
And one of the things we're going to be talking about today is respect and perspectives. And so it's fitting that Courtney and I are here because we kind of come at this issue from similar but different perspectives. I am a management side litigator, and I provide advice and counseling in my role as a defense litigator.
And I represent employees. I represent employees in all aspects of employment litigation and employment matters, from retaliation to harassment to discrimination.
Right. And so today here we're going to be talking about your rights with respect to workplace sexual harassment. And as we get started, it probably makes sense to touch lightly on a couple of things. And one is that, although we are lawyers, we're not your lawyers. We're not here giving legal advice. We're here to talk about best practices and knowing what your rights are. We may try to be funny, but that doesn't mean that that doesn't mean we'll be successful. It also doesn't mean that we take these issues lightly. It just means we're trying to bring a little energy to the conversation. And also that if we discuss anything that touches on borderline issues of inappropriate behavior, again, that doesn't mean that we don't take it seriously, but just rather that we're trying to have a good conversation. So what we want to do today is talk about resetting the context of harassment, because this is something that we've been talking about a lot in the United States and worldwide. And so really the idea is, can we understand the impact of today's client and the Me Too and Time's Up industry movements? Can we talk about making sure that everybody has a comfortable working definition of harassment, and also to understand, what your rights are and what you can do in your workplace if you feel like you've been experiencing unfair treatment. So again, today's climate with Me Too is something that since last October with the New York Times article and the Harvey Weinstein allegations, since then has really gotten more and more attention. And I think what we've seen is that the point of the Me Too movement is to create a sense of empowerment through empathy. And the idea being, as more and more and more people spoke up, more people felt comfortable speaking up, and that they had more of a context where their complaints and concerns would be received.
Yeah, I agree. And I think it would be good here to define harassment as it's defined under the law. And in California, harassment is defined as any conduct that's hostile, offensive, or intimidating that interferes with your work environment. And it has to be either severe or pervasive. It doesn't have to be both. So I think against that backdrop, we can talk about the Me Too movement and really what constitutes harassment.
Yeah, I think that's right. And that's certainly what the folks who spoke up and became the Time Person of the Year for 2017 were claiming they experienced with respect to their workplace. And so again, it does have to be extreme treatment. It has to be either severe or pervasive. One small incident isn't going to meet the legal definition, but that doesn't mean that you don't have the right to feel comfortable in your work environment. Sort of looking behind the headlines, seeing people lose their positions, be fired, or be demoted or resign. I think it's helpful to think about what's experienced more broadly than what we see on the headlines. And so I think it's helpful to keep in mind as we look through some of these statistics that 60% of women report having experienced unwanted sexual attention or coercion or crude conduct or sexist comments in the workplace. And at the bottom, you see that all of these statistics are coming from the 2016 Equal Employment Opportunity Commission Task Force, which is the federal agency that is responsible for ensuring a fair and equal opportunity workplace. Up to 56% of LGBT identified individuals report having been harassed in the workplace or heard derogatory comments. 70% reported that they experienced racial or ethnic harassment. 20% reported disability-based harassment, and 25% over the age of 50 have experienced age-based harassment. So again, these are pretty significant numbers when not just the headlines, not just the famous people or the high-profile people, but lots of folks are experiencing workplace environments where they feel like they're not treated fairly or there are comments. And what I can tell you from the management side is that workplaces want employees to have a fair and comfortable work environment. They want people to speak up. They want people to feel like they have an equal shot and equal treatment at work. What they can't do is, they can't enforce with every police, I suppose is the word, every person all the time. And so that's why some of these laws come into place. If there are individuals in the workplace who aren't treating others fairly or making comments, then that's where some of these techniques and tools we're going to be going over with can really help.
And I would add that sort of add a caveat that the vast majority of employers do want you to speak up, but there are those employers who unfortunately maintain a culture where if you do speak up, retaliation occurs. And like Demery said, a lot of times it will be a supervisor or a rogue manager. It's not necessarily coming from the CEO, but in the workplace, if there's a supervisor or a managing agent, that can cause a company to be liable for the acts of that supervisor or managing agent. And, we can talk about stories we've heard later, but unfortunately, in some contexts, we do see, at least in my practice, HR acting as the retaliatory and, retaliators. And unfortunately, that sort of silences the rest of the workforce. But again, as Demery said, the vast majority, I think, of employers want to do the right thing for their employees. So,
yeah, I'd agree with that. And I think everyone would agree that these laws are there for a reason, to set a baseline standard of what is acceptable and what is required. On top of that, most employers, I would advise all my client employers to have policies that are even broader than what the law requires, so that even if under the law severe and pervasive conduct is what's required, most employers have a much shorter leash on what's acceptable and want really a respect-based workplace. And again, not all, but most HR folks should be a resource for you. Resource is right in their name. They should be the ones you could go to if you have a concern. Thinking about the effects of harassment, this is some data that was put out by the Equal Employment Opportunity Commission through 2017. These are hundreds of millions of dollars collected by the EEOC per year. And it looks like there was a little bit of a downtick in 2017. It's important to note that their financial year closed in September, and that the Harvey Weinstein allegations and the momentum with Me Too started at the beginning of October. So we don't have the data on whether there have been an increase in complaints since Me Too really became a movement. That said, if you ask the acting director of the EEOC at this time, Victoria Lipnick, she's saying that there isn't really an increase in filings, but there is an increase in complaints. And that's kind of, I think, what Courtney and I are both saying, that it's good if people raise concerns internally, even if it's further back in time. It's good if employers know about this.
Yeah, and I would also just clarify, when we say collections, and I don't know what the EEOC is saying, but to know that there are multiple components of damages in an employment case. And I think that one component is economic damages. So let's say, someone is wrongfully terminated. The damages start to accrue based on what they would have earned had they still been employed up until trial, and then post-trial after, for a period of years based on the jury's determination, as well as emotional distress damages. So feeling anxious, sleepless, nauseous, the emotional impact of harassment. And then there's the third component, which is not always applicable, is punitive damages to punish the company for the conduct that occurred. And sometimes there's awarded and sometimes they're not even allowable by law. So that's what I would add.
That's right, exactly. There's both the economic and the qualitative component. And so this slide gets at trying to point out some of those. No, exactly. And you gave some really good specific examples, nausea and sleeplessness, but those all fall under, those are all under sort of psychological or physical harm. But there's also, and this goes not just for the individual experiencing an unfair workplace environment, it's bad for everybody if you don't have a fair workplace, because people's productivity suffers, or there could be job turnover. So, fundamentally what we're getting at is that it's in everyone's interest to have a workplace that's free of harassment, discrimination, and retaliation. So what can we do? This is probably where we want to start moving into some of the tools we want to give you. And what can we do? Just like with the Me Too movement, creating that empowerment, creating that situation where people will speak up, we want to reframe our approach to harassment prevention. We want to make sure that in the workplace, fairness, civility, and respect are guiding principles of how people interact. And the reason that's important is, like I was saying, although there's the severe and pervasive standard for extreme behavior for a lawsuit, we want to make sure that behavior there's a buffer zone around that kind of behavior, that's something that people are treating each other much better than what the law requires, so that you don't even get close to a harassment environment. Make sure you're aware of situational risks, whether that means alcohol in the workplace, or people who are feeling like they're marginalized, or anything like that, where you might feel someone who is isolated, a new employee who's much younger, people who, if you have supervisors who feel that they're above reproach or too protected, these kinds of concerns are situational risks. You want to make sure that all employees feel encouraged to speak up, either for themselves on behalf of others. And you want to know how to recognize that problematic behavior and what to do next, which is something we'll be talking about a lot. Do you have other thoughts on?
Yeah, no, I think that's perfect. I think that the buffer zone is really what you want to create, because I think that employers sometimes tend to underestimate the impact to the whole workforce when one person feels isolated or harassed or what have you, even if it doesn't rise to level. I think that people, and I hear this from witnesses all the time, that they tend to sort of not want to then come forward to raise concerns, or they just, they too feel intimidated. So I think the buffer zone is a perfect way to put it.
Yeah, and I think we can all agree that that's a good thing to have. We started talking a little bit about the definition of harassment, but really it comes down to fairness. And an equal employment opportunity workplace has three things. It's free of employment discrimination, free of harassment, and free of retaliation. And the way to think about these things is discrimination is an employment decision based on a person's protected category, which we'll talk about in a second what those are, and that interferes with equal employment opportunities. So discrimination refers to a decision. Courtney, when we talk about an employment decision, what kinds of things in the workplace would qualify?
I mean, anything from a demotion to a wrongful termination. Sometimes, employers will couch it as a transfer, but they're also taking away job duties and, sometimes wages. So I think when people think of the decision, they often think of just the demotion or the wrongful termination.
Yeah, the big ticket items of being hired or who gets fired.
Failure to hire,
all
exactly.
Those things. But it can be more subtle than that, just like you were saying.
Yeah.
Who gets promoted, demoted, who gets invited to trainings, who gets staffed on what matters.
Some of the harassment that I see time and again, it's almost textbook, is that, an employee will complain to me, I'm being isolated, so people aren't returning my emails, people aren't looking me in the eye. If I ask a question, my manager will direct the response to another employee. They're basically telling me to go home early, or you don't even have to come to work the next day. That was a sort of more egregious one, and I don't know why an employer would say that to an employee, but it's sort of, those are the textbook examples where employees just feel isolated. Mm-hmm. And, sometimes it's intentional and sometimes it's not. But when I look for harassment and retaliation, that's the kind of thing that I hear time and again.
Yeah, exactly. And so it could be an employment decision excluding somebody. Harassment is more what you feel as far as mistreatment. That's behavior in the workplace. And
Yeah,
so I
that's what I
suppose
was
your
touching
your
on,
example, but excluding someone could become discriminatory if it impacts their opportunities in the workplace.
I agree. And I think the other thing I was talking to Demery about before we started was there is a California case, Supreme Court case, which says that a personnel action, so from a supervisor or a HR representative, can be grounds for harassment. And it's a really limited sort of case, but, and the case for anyone watching is Roe v. versus McKesson, but so in that case, there was an HR representative who discriminated against the plaintiff based on disability, but they also held that the HR representative's actions by discriminating against her also predicated the claim for harassment. And so in that circumstance, discrimination and harassment can sort of be predicated on the same grounds.
Yeah, exactly. And then the last one is retaliation, and that's where someone has an adverse action. Same thing with discrimination, whether it's being fired, being demoted, reduction in pay, that adverse employment experience against employees who either participated in protected activity, which is bringing a good faith complaint or participating in an investigation, or who kind of stood up and raised their hand to oppose an unlawful employment practice. And so that would be a reaction. So if you think about it in sort of just everyday terms, it seems to cut through a lot of the legal mumbo jumbo to just making sure that all the decisions you're experiencing at work are fair, that the behavior you're experiencing at work is fair, and that the reactions to your behavior are fair at work.
Yeah. And I would just add for retaliation, one of the things that you look for, or at least I look for retaliatory behavior, is proximity or closeness in time. So if the employee complained and then a day later he was fired, that's what I mean by closeness in time. If the employee was pregnant 5 years ago and then 5 years later she was fired, courts have held that's just not sufficient. And so I mean, there's a number of factors you look at in order to prove retaliation, but closeness in time is one of the ones. It just makes sense. It's intuitive.
Exactly. And so we talked about both with discrimination and harassment that the behavior or decision has to be tied to somebody's protected category. And so not all adverse employment actions at work are going to be illegal or even violate company policy. There are absolutely grounds on which it is fair and reasonable for an employer to demote somebody if they're not performing or if they don't hire someone because it's a merit reason. But if it is tied back to one of these protected categories, that's when there start to be concerns about harassment or discrimination. So I think this is a pretty interesting place to take a look and see. I think a lot of them will look familiar and not surprising, and some other ones may come as a surprise. The outer wheel are the federal bases for discrimination and harassment. They include age, gender, sex and pregnancy, race, ancestry, color, religion, national origin, disability, genetic predisposition, veteran status, and citizenship status. I find a lot of people are surprised to know that not all ages are protected. You think that you can't discriminate against someone at any age, but it's actually only over a certain age that the protection kicks in. And I would submit that it's a very young age indeed. Some people might guess that it's 60, 70, 80. It's 40. 40 is the age when you are considered so old that you need protection. So young. I get questions sometimes on genetic predisposition. People say, what is that? And I think the best example that people are familiar with is Angelina Jolie had the breast cancer gene test done, right? And so once somebody's genetics indicate that they might have a predisposition to a certain medical condition or disability, then they're protected. You can't say, I'm not going to hire you because you're more likely to get breast cancer or more likely to get X or Y disease. And so it really is just another nuance on discrimination. The California categories, the one main one that is broader than anything under federal law would be the sexual orientation and gender identity and expression. The others are more expansions on the federal laws. So for example, California takes a broader definition of medical condition than disability. It's an easier threshold. So somebody is protected for a condition that might not be a disability impacting their day-to-day life or ability to do their job, but is something that they still are protected about.
Yeah, and I would also add to that in terms of pregnancy. I've found that pregnancy is much broader in California because in addition to the Fair Employment and Housing Act that you also have a pregnancy disability
That's right.
discrimination law. And so under the Fair Employment and Housing Act, you're protected for pregnancy under the category of sex. So they consider pregnancy discrimination sex discrimination, which makes sense. But you're also protected from the disability of pregnancy under the pregnancy disability law. So
that's right. So we talked a little bit about harassment and the definition of it. Courtney gave us a really good threshold working sense of what the definition is. She talked about unwelcome conduct. It has to be beyond what a reasonable person would consider. It has to meet that extreme, severe, and pervasive standard, and it has to tie back to somebody's protected characteristic or be sexual conduct in nature. I think that what we also see is people having misapprehensions or misperceptions about an element that is not part of the definition of what sexual harassment, and that is intent. So the person who is engaging in the behavior, their intent is irrelevant. Yeah. It is how it is perceived by a reasonable person. It has to be unwelcome to that person, and it has to be reasonably offensive. So somebody who is overly sensitive, just because they don't like it doesn't mean it's harassment. But at the same time, even if the person who engaged in the behavior meant for it to be funny or it wasn't directed at them, any of these reasons are irrelevant to the inquiry of whether or not it's harassment.
Yeah, I mean, and I would just give an example of that. I've had a case where a supervisor was sending a client emails with, a really, sort of, he thought it was funny, and they were sort of mocking the client for his age, but every witness who we spoke to said the supervisor didn't necessarily believe that it was malicious, but I think that it just, because it was so pervasive, it rose to the level of harassment, in our opinion.
Yeah, and this is a good example of what we're talking about, of that speak up culture, that supervisor may have, not necessarily, but may have, if somebody had said, oh, I don't want to see that at work, or I don't, that supervisor might have stopped and gotten their course corrected early on before it became a big problem. Maybe not. Maybe they would have said, I'm the supervisor, I say what's okay.
Yeah, that is what happened. But I do agree that, a properly trained and competent supervisor would have stopped. And I agree with Demery. That's why it is so important to speak up. And one thing I would just add to that is, and I know we're going a little off topic, is that I have clients all the time who come to me and say that they were afraid to speak up, and that's why they didn't speak up. But I have to say that that's what protects you in the workplace. By speaking up and protesting or opposing harassment based on any of the wheel categories or discrimination based on any of the wheel categories, that's protected activity, such that if you are retaliated against after that and because of that, then you are protected. But if you don't say anything, then and someone retaliates against you, it's very hard to prove.
That's exactly right. A good faith complaint, raising a concern in good faith, and not just trying to get out ahead of performance management by making up a nonsense claim, 100% protected under the law if it's a good faith complaint. Even if you were, at the end of the day, the company investigates and says, there wasn't anything going on there, but we appreciate your raising it. You don't have to be right. You just have to be sincere in the concern.
Yeah, I would agree.
Okay, so harassment kind of comes in two different flavors as far as the workplace and what people experience with behavior. One is quid pro quo harassment. And some people thought that this was gone, that this was sort of 80s harassment and it didn't exist in the workplace anymore. This is the kind of taking a tangible action based on an agreement or refusal to engage in sex. So it's linking a benefit at work or a threat with behavior that's related to sex. So that's also called economic harassment. And I think before Me Too movement, people thought that this was something that had maybe not been as much of a problem as it used to be. But I think we now have seen that it's just not been raised as a concern, and now it is.
Yeah, and I definitely still see it in my cases, and it's unfortunate. But I think that what I will say is that if someone's going to engage in at least sexual harassment work, what I found is they're just unabashed. If they're going to do that, they're not necessarily thinking rationally, and they're not thinking that if I make this person's job contingent on whether she engages in a sexual or he engages in a sexual act with me, they're just doing what they're doing, and it is,
I think that's right. And so there's either a willful blindness to it, or an optimism that is not warranted, right? That they believe that because someone's going along with a behavior that it's welcome, when really the person may feel that they don't have a choice because of the power dynamic. And so when you have that power dynamic with a supervisor and an employee, it's, again, not about what the supervisor intends. They may be thinking, wow, this is great. I'm getting a new dating partner here at work. But if the conduct's not welcome and the behavior is not acceptable, then it's going to, at minimum, violate your company policy.
Yeah, and I love how Demery put it, that it's economic harassment, because it really is. Because when you have an employee who needs their job for their livelihood and they're being harassed, a lot of times they feel compelled to put up with it because supporting their children or paying their mortgage is more significant to them than, whatever the harassment is that they're experiencing. And that's not to downplay the harassment.
That's right. And that's something that's come out of this Me Too movement as well, is that forced consent is not really consent at all. And as we were sort of alluding to, only a supervisor can engage in this kind of harassment because only the supervisor has the power to give the benefit or make the threat. Now, on the other hand, the other kind of harassment, there's economic, the other one is environmental. And that's sort of the hostile work environment that where there's that, this is a definition that Courtney was kind of leading in for us with that unwelcome conduct based on the protected category, has to be unreasonable, and it has to be either interfere with their performance or meet that severe, hostile, or offensive standard. Exactly. And I think what's again missing from here is intent. Missing from it is, they acted like they liked it. They didn't say no, all of these things. It's really incumbent on the person engaging in the behavior to be aware of the welcomeness.
And I would just add to interfering, just to give you a few examples of what interfering sort of looks like is, as I mentioned earlier, if you have a supervisor who's not returning your emails because you're a woman, because you have a disability, that's interfering with your work performance because you're not able to perform your job. Likewise, if you're not getting included in meetings, or your questions aren't getting answered, that's interfering with your work performance. So I mean, it can take the form of so many iterations, but it's just very you see it, unfortunately.
And I think that Courtney and I would both agree that that harassment could either be very overt or very subtle, that both exist. But I think the one thing that I certainly would take the position is that not everything is harassment. It has to be tied to protected category or sex. It has to be intended on one of those categories. So again, say somebody is chosen for a layoff at work. There's going to be a big layoff in a warehouse, and 10% of the workforce is chosen. So the question is, were those decisions, those choices made based on a protected category, or were they legitimate and fair decisions? And so that's where it's sort of our job to sort through that. But I'm always telling my clients, make sure that you're making fair decisions.
Yeah, I would agree with that. And, as an employee, representing employees, what I look for when a potential client comes to me and there has been, let's say, a layoff, I say, well, how is your performance? I ask for their personnel file. An employee has the right to their personnel file in California. And I look, and a lot of times, I will see performance problems, and it, to me, as as objective as I can be, it does seem like the layoff or the reduction in force was not targeted at this particular client because of a protected category. Likewise, I've had clients come to me and it's a reduction in force of one person, and in that case, it's somewhat suspect. And then if I dig in a little more, sometimes, it has to do with a person's to me, it seems like it has to do with a person's previous complaints, a few months before. But, it sounds like Demery is advising her clients perfectly.
Yeah, and that time connection can be an example, or just harassment in general if you've experienced comments or that relate to race or any of the other protected categories, age, national origin. That might give a little more of a feeling that a decision is tied to the protected category, but in the absence of those other indicators, it's going to be more, it's more seems like it could be something that was a fair decision. Okay, so, and again, if you're not sure why you were the one who was laid off, or even why you had a bad performance review, you can ask, you can say, this felt fair, or what can I do to do better? You can take ownership of your life, your career, and ask and feel empowered to engage in that conversation. And I encourage everyone to do that. We talked a little bit about kind of behavior or comments, things that can become harassing, and I'm sure Courtney has a million experiences from her clients. I'd love to get some examples because it can take different forms. It could be physical with touching. I have complaints on my desk where someone's alleged to have put a hand down a shirt or grabbing a bum and all these things. It could be verbal comments about the protected categories or just making jokes about general inappropriate or lewd things. Or it could be visual. It could be, in the old days, pin-up posters. I don't know if they do those anymore. But it could also be things with phones, showing a funny or not so funny meme that relates to protected characteristics.
Yeah, I would agree. And I mean, and I'll talk about it more later, but I think that, the verbal I've seen has ranged from using very inappropriate language. Courts, I don't know if I can say this on camera, courts have said that the B word constitutes a sexually offensive word when used in the workplace, and it can predicate a claim for sexual harassment. Obviously, there needs to be it can't just be a one incident, but I've had employers alleged to have said women can't work, they need to be home cooking for their husbands and children. I've had it runs the gamut. And
Mm-hmm.
so, and in terms of the touching, as Emery said, I've seen everything from very severe sexual assault to just, putting the hand on the small of the back as you're moving someone towards a door, but doing it repeatedly. And then that combined with other conduct will, many times, at least for me, give rise to a claim for harassment.
And I think that's right. And it ties back to what we were saying at the beginning about workplace policies having, again, the buffer zone of behavior and comportment that is more strict, a higher standard than what's not allowed in the law. And so you can even go back to getting along, playing well in the sandbox and saying, let's give everyone our bubble space, and those are, again, getting closer to someone physically, not necessarily going to support a claim for harassment under the law, but certainly is a respectful standard to have at work. And I think that it's also important to remember that the behavior is not just what takes place in the workplace, but what happens outside the workplace. And what I tell my clients all the time is that you have to keep your employee hat on at all times. That is always the main threshold for the relationship. Even if you're at happy hour, even if you're traveling for work, even if you're dating a coworker. Now, these things aren't illegal. People meet their significant others at work all the time. It's a time-honored tradition. It happens and it's lovely when it works. But you want to make sure that you're still respectful, that the behavior is warranted and consensual. And if not, then you're crossing boundaries.
I agree.
Okay, and so again, giving people some tools about sensitivity, what we want to do is make sure, when we've talked about a number of these things already, but again, it's the perception of the person who's subjected to the conduct that matters, not just it's welcomeness to them, not the person who's engaging in it. And so everybody needs to be paying attention to how behavior is perceived by others. And it's not, I don't think it's a secret that lots of people don't feel comfortable saying no or stop or I don't like it. So I think it means that's incumbent on us to make sure we're following our workplace policies and having a safe and respectful workplace to be attuned to behavior that's more subtle than just a no, whether it's crossed arms or stepping away or avoidance behavior or I can't or not responding at all. These things could mean that behavior is unwelcome, those kinds of body language experiences, and it's something that we could then take our cues from to gauge our behavior and make sure it's welcome.
Yeah, I would agree with that.
We see with social media too, we talked about that as a place where verbal or visual harassment can occur, but it's just gotten so prevalent, as we all know. It's very helpful, it's a great connection, it helps us get things done more quickly, stay connected with others, but those connections can also be a place where inappropriate behavior can take place. I'm sure you've had texts in your...
I have.
Yeah.
I mean, I would just give one example that I can think of off the bat is I've had supervisors sending memes or like sort of popular culture images to an employee, and they've been very inappropriate images or scantily clad women, and I just think to myself, what are you doing? Because this is preserved for posterity.
Yeah.
And I think it makes it really easy nowadays. Just press send and then you don't even think about it. And I've gone through reams of text messages before where I'm like, this guy doesn't, what was, the thought is, what is he thinking?
Yeah, people lose their good judgment when it comes to social media. They would never print it out and put it in front of somebody, but for some reason it feels like it's a different standard in the moment, whether you're sitting on your couch, and so maybe that's why it doesn't feel like it matters, or because it's not, I didn't create it, I'm just sharing it. I don't know what they're thinking, but it still counts. And so it's important to remember that, again, if it's extreme and pervasive and severe, then you still have to be below that standard with social media. Another thing to touch base on is that it's not just your coworkers, but you want to make sure that you are refraining from engaging in harassing behavior with respect to third parties, whether that's the FedEx person who comes in, or the water delivery person, the lawyer who comes in to do a training, whoever it is. We can't come in and harass your co-workers or you, and you also have to make sure that you're not creating a harassing or hostile environment for others. And so it's just, again, as Courtney was saying, people don't think, or what were they thinking? And so we are encouraging everyone to please think before you engage in those behaviors. A few action items to take away would be for you to make sure that you understand your policy at work. If you have a workplace where you have a policy for workplace behavior, you can either refer to it if you have it, look online, or ask for a copy. That's perfectly fine. And if you have questions, ask them. Because as I keep saying, what behavior crosses the line of harassment is subjective. It has to be that extreme. But most workplaces have, again, that higher standard. So you want to understand your policy's expectation and understand what's expected of you, follow it, and then conduct yourself with respect, self-respect, and respect for others. If you have any questions or concerns about that, please, I do encourage you to partner with Human Resources or your supervisor, whoever you feel comfortable with, because like Courtney was saying, that act is protected, so you should not fear reprisal for it. I'm out there telling my clients, if someone brings a good faith concern, you got to respond to it in good faith.
Yeah, and I would just, sort of emphasize the second to last bullet point, because a lot of times I've seen employers waving around this beautiful policy, which is totally compliant, but their employees and supervisors are not following it, and it's really problematic, I would say.
That's where the problems start to arise. So we promised you we'd give you a little bit of a roadmap of what to do in the event of issue. So if people aren't following these rules that we've laid out, whether it's the workplace policy or even something that would get closer to a law violation.
Yeah. Is this?
Yeah,
Okay.
That's, you're going to go forward.
Okay.
That back.
Oh, is that back?
Yeah. There you go.
Okay. Mm-hmm. So this is the roadmap for a typical complaint. So how do I complain? I always advise my clients to put it in writing. An oral complaint definitely, or verbal complaint definitely suffices, but it's good. It protects you and it protects the employer to have it in writing. And I think it will help you articulate your thoughts. It doesn't have to be perfect. It doesn't have to cite the code section or cite the law, but to explain what's happening to you. And that's where the next bullet point comes in. You want to be as specific as possible. It's not required, but this again is my advice to clients. You want to specify the who, where, what, when, and how. You want to specify who committed the offensive acts that you were offended by. When did these things occur? If it happened on multiple occasions, say that. Say, this is happening to me every day. This is happening to me weekly. What was done that was offensive or made you feel uncomfortable? So if someone's touching you or leering at you or staring at you, if someone's using inappropriate language, you want to specify all of these things. And again, how often have these things occurred? So that goes back to, when did these things occur? If it occurred on multiple occasions, you want to say that. And then where did they occur? Again, these things are not legally required, but I think it helps Human Resources address the complaint, and I think it'll help you put your thoughts into writing and sort of convey exactly what is happening to you.
Yeah, and from the employer's perspective, it gives them more to respond to, and it gives them a roadmap of what action to take and where to guide what they're going to do from there.
This is types of harassment. So we covered this a little bit earlier. Sexually offensive language, the term bitch.
People say it.
People say it. Courts have held that that is obviously inappropriate language in a workplace, and you can predicate a claim of sexual harassment on someone repeatedly using this term towards women because it is pejorative and it makes women feel unwelcome in the workplace. Sexual advances, either written and or oral or verbal, of course, that is something that, it's sort of intuitive. Inappropriate conduct towards others, and I would emphasize the last three words, in your presence. So let's say you have a manager who is harassing someone else. They haven't touched you, but they're harassing someone else. That is conduct that you can use to support a claim for sexual harassment. But again, I have to emphasize, you have to have personal knowledge of it. So if it's not in your presence, then the person must have told you about it. It can't be like, I read on social media that blah, 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 blah happened. Leering and touching.
Yeah, I think these are all things that people experience to various degrees at work, and the question in people's minds may be, is this harassment? Is this going to be a violation of the law? And the answer to my mind is it depends. It depends on how extreme it is. It depends on how many times it happened, the unwelcomeness, how offensive. And so, but these are definitely kinds of things that if they're happening at your workplace, then I would encourage you to raise it in your complaint. Absolutely.
And this goes back to the interference with your job duties. In your complaint, if the harassment is making it more difficult for you to perform your job, I would say that, I'm not able to perform my job duties because my supervisor isn't responding to my emails, or I'm not getting invited to these key meetings which are necessary for me to perform my job. And the second bullet point goes to the emotional distress component of damages, that if the harassment is causing you to feel sad, anxious, depressed, or otherwise physically ill, say it. And what I would emphasize is what Demery said earlier, is it has to be a good faith complaint. You can't be setting yourself up to build this zillion-dollar case, but at the same time, by documenting these things, if for some reason the employer does not take the correct action, if you get wrongfully terminated, these are things that you can use to help you down the line. Say, look, I'm not making it up that I'm, unable to sleep. I said it way back in, 1986. Third bullet point is obviously these things are very important to document.
Yeah, I don't disagree.
To whom do I complain? What I would say is send your complaint to your supervisor if he or she is not the harasser, and send your complaint to Human Resources. I always advise my clients to not just complain to one person, because if it's the supervisor, if it is the supervisor and you do feel comfortable complaining to him or her, maybe he or she will stop, and as Demery said, that you can't stop doing something that you don't intend to be malicious if you don't know that you're doing it. And then also definitely to Human Resources, because that's the entity at your company that is tasked with investigating this type of conduct. And I do have clients who are at employers where no HR department exists, and if no HR department exists, I always say send it to the highest level individual at your company, so he or she is on notice that this conduct is occurring, and he or she can retain an outside entity to do an investigation.
Yeah, I think that's right. And I think that this example of the steps to follow is perfect for if you're experiencing something that's fairly severe, or that you feel is not going to be resolved with just asking for it to stop. So I think a good example of a lesser situation that doesn't require, following all these steps, although some of them may be appropriate, would be, say you work with someone, your coworker, even a peer, is a hugger. Right? They hug you, not even every day, at the holiday party or whatever it is, and you don't like it. You have a right to not be hugged at work. And so you could start by simply saying, hey, I'm not much of a hugger, I'm more of a handshake person, or, and if you say something, that may be enough. And then you've avoided something more awkward by going into DEFCON 4 mode and bringing the CEO or HR into it. if that's enough to resolve the situation. It may or may not be. If it's not, then these additional steps will prove useful.
And I agree with Demaria completely. I don't think, when I'm outlining these steps, I definitely think this is more applicable, that if this harassment is, more likely than not occurring. But, so if you don't feel comfortable asking your supervisor or whoever it is hugging you to stop, HR is always there and they can take care of it.
It's their job.
What to expect after you complain. As we noted earlier, you cannot be retaliated against for complaining about harassment or discrimination in the workplace. It's unlawful under federal law, it's unlawful under California law. And retaliation, and this is not an exhaustive list, I would emphasize, can take the form of exclusion from meetings, phone calls, emails, a reduction in your job duties, removal from your position, or an escalation of the harassment. I have a client right now, and this falls under reduction in job duties, is after she complained, her duties were cut in half, they were assigned to a subordinate, there was no reason that I could see for that action to be taken. And so for us, that just seems like retaliatory behavior.
Yeah, it could take all different forms, from subtle to extreme.
Exactly. What to expect after you complain. In California, the law mandates that employers have an affirmative duty to prevent harassment and discrimination from occurring. And how do they do that? They do that by conducting an investigation, a good faith investigation into a victim's complaints of harassment, discrimination, and then retaliation should also be on there. And so I'm going to outline the good faith steps that they should be taken. There are cases that say if you provide witness lists to an employer and they refuse to interview any of your witnesses, that militates against or goes against the good faith component. So it seems like they want a predetermined outcome to determine that no harassment occurred. So after you complain, your employer will begin its investigation of your complaints of harassment and discrimination.
Yeah, I think that's right. And this just goes back a couple of things on that. It goes back to the putting the complaint in writing. That helps the employer to conduct the good faith investigation. Yeah. It gives them something to go on and where to start. And then from there, they do have to do a reasonable and thorough investigation. I agree with Courtney that they shouldn't ignore a list of witnesses, but I also know that if they get a 40-person list, they may not need to interview everyone on the list, but they should not ignore a witness list provided by an employee.
I agree with that completely. So the employee will, maybe Demaria can correct me if I'm wrong, but I believe they should always be interviewed by human resources, preferably in person, but for very large companies or even larger companies, that's not always possible because people are in different locations. But if it is in person, it gives the employer more of an opportunity to judge credibility, judge any number of things. And this is what I advise my clients to do during an interview with an investigator. I just say to walk the investigator through as if they were, in elementary school, the reasons why you believe you've been harassed or discriminated against. So, you can use your complaint to provide a roadmap for that. I always tell my clients to provide identities of witnesses. If this conduct occurred and there are witnesses, they should be interviewed. And let's say someone saw your supervisor grab your breast, that witness should be interviewed. If you have documentary evidence of your claims, provide it. So there's text messages. If you have inappropriate text messages, provide them. Be completely honest. This seems like a no-brainer. Do not exaggerate. Do not, undersell your complaints. Be completely honest, because your credibility is everything in these types of cases. And if you sort of overstate something, but something actually did occur, the investigator may conclude that you're not honest when maybe something did occur. And I would say take notes. I always tell my clients, ask them first if you can take notes, but I don't see any reason why an employee shouldn't be able to take notes when they're talking to an investigator. Answer every question asked of you to the extent you understand what you're being asked. So if you don't understand a question, ask them and say, I don't really get it. Could you ask me that in a different way? But, I always say to my clients, you're not in an oppositional role at this point. This is your employer. You want to make this right. They should want to make this right. So to the extent you can help them conduct their competent investigation, their good faith investigation, you want to do so. And ask what steps will be taken to protect you. I think that it's not required, but I think that provides people some peace of mind if an investigator then responds, look, we're gonna, remove your supervisor and put them in a different area for now, or you're gonna go into this area, it just sort of ask what can be done.
Or even just that everyone's being reminded of the
Yes.
anti-retaliation policy, and so everyone's been reminded that no one should have any adverse consequences for having raised this concern,
Exactly.
or things like that. One thing that comes up sometimes is whether whether people can refuse to participate in an interview or anonymous complaints and things like that. Those are sort of nuanced. Yeah. I guess the reason I've touched on it here is because Courtney raised the point of the follow-up that is required by an employer for an investigation.
Yeah.
An anonymous complaint, or if the complaining party isn't willing to be interviewed, makes it harder.
Very hard.
Yeah, to investigate.
Yeah, and if something happened to you that is legitimate, it only helps you to be available for an interview. So this sort of goes along with that. I tell employees, while an investigation is pending, be the perfect employee. So do not discuss the investigation with other employees. There's no rule against that, but I generally say, unless you want someone to be a witness for you, in which case definitely tell them, like, hey, you witnessed him grab my breast. Do you mind talking to HR and being truthful about that? But don't stop showing up to work. Don't think that just because an investigation is pending, it's sort of a free pass to stay home and watch TV. And don't start being late to work. Again, perfect employee, because you don't want to give, and this is more aimed towards those employers who tend to retaliate when a complaint is made. You don't want to give them grounds to take any action against you. You want to preserve your protective activity for what it is. So again, you must always be responsive to the investigator who's tasked with investigating your claims. Don't avoid his or her phone calls. Don't put him off. Be available. It's okay to say, hey, I need a day to get my thoughts together, but be available. And provide more information if requested. Again, this person is not, while it may seem like it at the time, this person is not adverse to you. You want to treat this person as if they're trying to help you. And if they don't, then by all means, there's avenues available to you. But again, be available for further interviews, anything that the investigator needs.
I would agree. Yeah. And I think, too, that goes back to the respectful workplaces aspect that we've been talking about, that if you have a good faith concern that you've raised and are wanting to resolve it and have a safe and fair workplace that you can do your best and be your best self, then none of these behaviors would be consistent with that. So it's sort of counterproductive.
Exactly. So the conclusion of the investigation. A conclusion should be reached. Yay or nay, did the harassment or discrimination or retaliation occur? The investigator's findings should be communicated to you. You should know. So it shouldn't be like, we know what happened, but we're not going to tell you. And if the harassment, discrimination, or retaliation is found to have occurred, corrective action must be taken. So this can include, but doesn't need to include, discipline of the harasser. So suspension, termination, a transfer from the harasser away from you. I believe, and Demery can correct me, that there's case law saying that you don't need to be punished for the harassment that occurred. So you don't need to be transferred to another location 50,000 miles from your home. It's the harasser who needs to be disciplined. And training for the harasser. So again, reminding them of what is or isn't appropriate in the workplace.
Yeah, and these, again, are going to be very fact-specific,
Agreed.
Tailored to the circumstance. Was it just a policy violation? Is it something that goes into potential illegal behavior? And also sometimes what is best for both the complaining party and the responding party for going forward, for everybody, again, to have a safe and respectful workplace. It's going to vary case by case. And so I think it's important, the more you've participated in the process and made your feelings, concerns, wishes communicated, the more they can be taken into account.
I agree. Questions? Anyone?
Well, we appreciate everyone's time so much and participating. Yeah, did you have, yeah.
Who is the investigator? Is the investigator someone in HR, or who does the investigation?
So the question is, who is the investigator? Is it going to be someone in the HR department, an outside person? And the answer there too is it depends.
Yeah, I've seen HR departments, I've seen outside investigators. It really depends on the resources and the company's decision. It doesn't have to be one or the other.
That's right. It's a great question. Yes.
Can you expand a little bit on the point you made when you said that if there's not an HR department or someone in particular to point to, go to the CEO or the president? Can you talk about your experience with folks going directly out? Because in a small business situation, I would think that without a little bit of background or support, that could be an overwhelming thought.
So the question is about where you can bring your complaint if there's no HR, if you go straight to the top, and how that might impact the work environment in either a small or large place.
So I've seen it in small and medium-sized companies. HR departments are expensive. Outside investigators are expensive. And sometimes I think that companies don't even understand that HR departments will protect them by, having HR departments. So I've seen companies with, let's say, 50 employees, well, they maybe should have an HR department, they don't. And so I always say that you need to bring it to someone's attention who can actually take action, if it's actually occurring. And if I was a defense attorney, I would recommend that person then retain an outside investigator to investigate the allegation if legitimate, or if, it rose to that level. But that's why I say go to the CEO. I've had cases where the CEO is the wrongdoer, and so in that case, it's very uncomfortable for the client to go to the CEO. But I always, in my perfect employee side lawyer scenario, my perfect scenario is, even if the CEO is the wrongdoer, that my client sort of go to him, and if retaliation occurs, then it occurs, and that's on the company. But I think, and in the law it's called a managing agent, I think a managing agent needs to be made aware of the conduct that's occurring.
And I think, it depends on the situation. It depends on what the allegations are, how serious, what the resources are.
Exactly.
It depends on who the accused wrongdoer is and what the individual feels comfortable with.
Exactly.
If you have someone in a different department who is a manager that you feel comfortable talking to,
I agree.
then you can go there. We know it's a big ask to say, yeah, write a letter to your CEO, whether it's a small or big company. That may not feel comfortable. And so if it doesn't, that's okay. That's not a must, but it's a technique that can be helpful to resolve the situation, or helpful to make sure that things don't get swept under the rug if that's the concern. But if that's not where your comfort zone is, that's not going to defeat the fact that you've raised a complaint.
Exactly.
Mm-hmm.
Exactly.
Yeah, it's a great question too. Any other questions? Yes.
Will you be sending this PowerPoint to our email?
This will be available through the library as a recording.
Oh, so is that going to come to is that going to come through our email or PowerPoint?
The question is whether the PowerPoint will be emailed out, and the answer is no, it will not.
I don't know, this may be a dumb question. Sexual harassment is against the law.
The question is, sexual harassment is against the law.
How is it against the law where you can get law enforcement involved in it?
Okay, so the difference between sort of a civil violation of rights and a criminal situation is really where is law enforcement getting involved, and that it depends on the behavior.
Yeah.
So if there's a sexual assault or anything that would fall under a criminal type of behavior, that might be the right situation to go to law enforcement authorities, or that the employer may choose to do that where appropriate. But if it's just sort of the kind of leering, touching on the bum kind of behavior that we're seeing here, that's probably not going to be a violation of a criminal statute, then that's more of a civil situation where people, where the remedies are what Courtney talked about, whether it's the damages to the individual as opposed to any sort of fines or jail time.
So, for instance, a rape, or as Jeremy said, sexual assault.
Is there any other type of harassment that's not physical that may be considered criminal?
Harassment that's not physical that could be considered criminal. Well, yeah, so yes, I mean behaviors that threaten a person's safety that aren't physical, like a stalking maybe kind of situation. So again, this is the employment context that we're focused on today, but yes, there are behaviors by people, whether they're coworkers or out in the world, that the way they interact could obviously lead to a criminal charge. Terrific. Well, thank you so much, everybody, for your time. It was really a pleasure to speak with you, and we appreciate your attention and look forward to all of you taking this information and putting it to good use.
Thank you.